Good afternoon there, Roughnecks. Wrangler here. And today, this video that I'm going to show y'all is not going to be our normal comedy pointing, haha, idiot. It is a very, very serious case, and I'm actually a little appalled at the gall of the defendant, who is charged with some pretty heinous sexual crimes against children, is actually in Judge Simpson's court trying to get visitation rights on those kids. Anyway, please hit the like button and just prepare yourselves. And by the way, we would like to congratulate the channel Credence and Mikey for getting 100,000 subscribers. Congratulations.
Good afternoon, Your Honor. Ellen Michaels on behalf of James Worthington. My P number is 67943. Mr. Worthington is present in court.
All right. Your name, sir?
James Worthington.
All right. Very good. All right.
So today's the date time set for our second probable cause conference. We had adjourned it in order to get all the Child Advocacy Center videos. I'm short 2 videos, though I've been notified that they have been sent to me. So I believe we're ready to set it for exam, assuming that they in fact were uploaded today as stated by the prosecutor.
Well, based off of the charges your client has been hit with, I don't really think it's necessary for you to throw cheap shots at the prosecution, calling into question their ethics.
For clarification purposes, I have confirmation from the detective, the officer in charge, that they have just as of today been shared and made available on evidence.com. I've relayed that information to the proper individual in our office. I would expect that those will still be shared with counsel before the day is over. But just to be clear for the record.
All right. And if those are done, then discovery is complete.
Yes.
Yes.
Don't like to do it this way, but I get what you're saying, that it's there.
Understood, Your Honor. Thank you.
If there is a problem, I will bring it to the court's attention and file the appropriate stipulated motion in order.
Right. But that's what we try to give people time at PCC to get all that stuff straight and not set something and then have it adjourn out. So
Understood.
I want to make sure that we're going to be able to go forward. People had their witnesses available the 28th?
28th of
January.
Oh, I'm not available at all that day.
Well, Madam Defense Attorney, seeing as how you are the one trying to get these hearings scheduled, you might want to make yourself available.
Bond will continue.
I'm asking Your Honor to again revisit the bond conditions. What I'm simply asking is that my client be reunited with his children. He does not need to go back to the residence that's across the street from where the complainant lives. The family can stay with a friend in a separate location. But since the incident, that the 2 children of my client have been taken away, even though CPS has not filed any the case has been closed. There's no issues. The children are staying with grandparents, and this has been going on since early December.
All right. What she's saying, boys and girls, is that since the 1st of December, the children of the defendant here have been preemptively removed from his custody and care and placed into the care of someone else while it's being investigated. And this actually happens quite often. But in this, it's what's in the children's best interest. And what's in the children's best interest is that if their father is being charged with SA on their friends, then it's probably in the children's best interest to remain out of his care.
Your Honor, people continue to object to that. Again, as I indicated the last time you were here, the same request. I get that. I really do. I'm not comfortable agreeing to that because although I understand that defendant's daughter was interviewed at the CAC and did not disclose. That being said, our charged victim, her erstwhile best friend, in her CAC interview, where she made all of her disclosures, she indicated that his daughter also told her that she had been sexually assaulted, both by defendant and by their son.
Translation: that while his daughter has not disclosed to child advocacy workers that she was SA'd by the defendant, she apparently disclosed to her best friend, which is also one of his victims, allegedly. So, like I said, a lot of times children find it difficult to discuss being the victims of those types of crimes to other adults. It's not uncommon at all.
Well, I am concerned. I'm not willing or able to agree to change those bond conditions. Understanding, obviously, ultimately it's up to the court, but I am concerned for the safety of any minor child.
And I'm quite frankly, counsel, I'm in the same position I was the last time, I think. That I don't think anything's changed, and I denied the request the last time, and I don't have any additional information that would lead me in that other direction. So I'm going to decline. I'm not going to change its bond conditions.
Not gonna happen. No, not gonna happen. Not.
Can I just make a record on one matter?
Sure.
Thank you so much. My client's daughter, the prosecutor was talking about, she was taken by the police to University of Michigan Hospital and physically examined. There's no indication of any sexual assault. She was also, as stated, interviewed in a forensic setting and did not make any disclosures.
So what you're saying is because he cleaned up after himself, you're trying to say that the lack of evidence is evidence?
We believe this is all part of these are all false allegations, and the children, there's no evidence that his children have been assaulted in any way. This is part of the discovery that was tendered to me by the prosecutor, the medical records and her interview.
Judge, as I indicated last time, same record was made then, same arguments were made then.
I know.
Certainly the court has been doing this as long as I have been doing this. There aren't hardly ever medical findings when a small child has been sexually assaulted. It's all about timing. It's all about type of sexual assault. It's all about those areas of our bodies being fast healing. It's all about so many moving parts that a lack of medical information means zero things in terms of whether or not a child has been sexually assaulted.
One more thing, Judge, that the daughter allegedly said that my client penetrated her every single day. There would certainly be medical evidence of that. Thank you.
All right. So what you were saying is because there is lack of evidence, physical evidence of one aspect of the crime, that it didn't happen? No.
Would not necessarily be. Penetration can be a whole lot of things with a whole lot.
And again, I know you made your record, but I'm still at this point going to deny that. Judge Valvo, after the happens, may feel differently, and certainly you can bring that before her. But at this time, I'm going to deny the request. Bond will continue.
Thank you very much.
Thank you.
Thank you.
All right, ladies and gentlemen, that is that. Like I said, this wasn't one of our normal videos. And to be honest with y'all, my curiosity is piqued a little bit. So I am going to look into this case and this guy just a little bit more and see if there's anything else that is worth bringing to you all. Thank you all so very much for being here, and thank you for bearing with my doing a video in a little bit different context than normal. Thank you all so very, very much. Anyway, it's Wrangler. We're out of here. Love y'all. Have a good one.